Hi, I'm attorney Jason T. Brown, and I'm here to talk to you today about holding banks accountable for PPP loan fraud. We've talked quite a bit about PPP loan fraud in the past, the Payroll Protection Program, a lifeline to small businesses, which was exploited in the tune of tens of billions of dollars by criminals and, quite frankly, certain businesses that weren't worthy of receiving the taxpayer dollars. What do I mean about being worthy? Well, there is a defined set of criteria put forth and promulgated by Congress and the SBA about what qualifies a small business for eligibility and certain caps to be a small business. For example, for the first round of PPP loans, it was 500 employees, $10 million, and a lack of interrelated companies, so that way you can bust through that cap. In the second round, it was 300 employees, $10 million, and you also had to show a deficit in a quarter. What I mean by that is a fiscal quarter that was deficient from one year over year in which the business didn't do as well as it did in the prior year. So who are the people and entities committing PPP loan fraud? Well, there's outright criminals, which we've discussed. The problem with that is those are going to go purely criminal, and there's not much a lawyer can do for you if you know of an entity that's just an outright criminal, particularly if they're overseas, which a lot of the crime unfortunately happened. But besides criminals, there's the smaller businesses in which there was inflation. And when I say inflation, where the small business may have inflated its census, its payroll cap, its employee headcount to receive more than what it was entitled to. Those cases, our whistleblower law firm predict, may not go so well. And there's deflation, which we think are maybe very actionable under the False Claims Act to address this. And deflation is when the business in fact had over 500 employees, did over $10 million, hit interrelated companies, and in fact received money that when it shouldn't have been eligible in the first place. Those cases we think are going to be actionable at the end of the day under the False Claims Act because the defendants will be solvent and be able to pay. And if they conceal the interrelated companies, the act of concealing them, scienter, knowledge, understanding that somebody did something wrong or an entity did something wrong. But there's a whole other potential defendant in this fraud, and those are the banks. Now, under False Claims Act doctrine, the idea is the guilty party, the people who have bad intent, will be held accountable. So just because a bank processes a bad loan doesn't mean the bank would be accountable for PPP loan fraud. However, I think when we start to think about this, and based upon the information we already know from various sources, I think certain banks will be held accountable for PPP loan fraud, and certain individuals who work inside the banks, if they disclose information, may be eligible for quite a big whistleblower award under the False Claims Act. Let's take this from two different tracks and two different perspectives. There are the bigger banks and the smaller banks. And the bigger banks have protocols and controls that they were supposed to have gone through in order to issue these PPP loans. And these controls are what give them protection, and these controls are what may damn them. And what I mean by that is scienter is knowledge, and not just being knowledge, but scienter may be if somebody was extremely negligent, maybe that gross misconduct constitutes scienter under the False Claims Act. So generally, if a business was doing banking with, I don't want to single out any out big banks, but we'll call it big bank number one, and big bank number one knew that business's employee headcount was 2,000, and their banker works with them all the time at the big bank, and then all of a sudden in one pile of documents they know it's 2,000 employees, but in the PPP loan they see the certification for 500. Well, at some point the bank may be held accountable for that type of willful ignorance. Now, the bank's defense may be in these circumstances, hey, here were the defined set of criteria that made a business eligible to receive PPP loans. We only looked for what the federal government told us to look. However, I think at the end of the day, if the company had a policy to willfully disregard information that it had in front of it, that the bank had the policy to willfully disregard information that in ordinary circumstances, in ordinary controls, they would have looked at, but they threw away the controls in order to get businesses PPP loans that they knew wouldn't qualify due to headcount or gross revenue, there's a colorable argument to be made, I think, to hold the bank accountable. I think it's a hard argument to make from the outside. The companies and entities that receive the loans probably don't have the knowledge and the landscape and visibility to penetrate how wide of a scheme it is. So I think one of these cases against the big banks would have to be made from an insider who's at a pretty high level, either regionally or nationally, and understands what occurred with the banks and the big banks in giving out these loans. So to summarize the big bank culpability, yeah, there's always a possibility that they committed outright fraud. Maybe even a rogue branch or two may have done that, and maybe there's culpability there. What we're looking for is a systemic practice by the bank to willfully ignore what's in his file about the business in one hand and instead submit something contradictory in the other hand. And in that case, the big banks may be held liable for widespread PPP loan fraud. And PPP loan fraud, it's just a term I'm throwing about, but you know what that is? Defrauding the taxpayers out of money. It's also shorting other businesses who needed this money in a time of need and taking it for an entity that didn't deserve it, compromising the integrity of other businesses that needed this to stay in business. Let me move on to the smaller banks. In contrast to the big banks, where there's better controls in place, it's the belief that some of the smaller banks may have approved PPP loans just for the commissions when they were fully aware of the fraudulent nature of those loans. And in contrast to what we said very early and what we've been saying very early, were these small PPP loans for $20,000, $30,000 under the False Claims Act, we don't think it's going to be very actionable or recoverable. Well, if the bank has some culpability, it may be very actionable and very recoverable. So if there is a bank out there, and a smaller bank, regional bank, that was just throwing out this money to friends or funneling money to an entity that they know really had multiple cogs and was just outright fraudulent, it could be that a small bank is part of the scheme and not only is liable through negligence, but in a higher standard, liable because it actually had willful misconduct from this very inception. The key is, if you're inside a bank and you understand or think you understand that something has happened wrong with PPP loans, their distribution, their forgiveness, who received them and why, you pretty much should speak to a PPP loan fraud law firm, a firm like Brown LLC, but doesn't have to be our firm. We only take cases on contingency and are only paid if we win the case. But you really should understand your rights, because if you were one of the people who were in the chain of command to give out these loans, and all of a sudden somebody else, person to your left, person to your right, is blowing the whistle, when the FBI becomes knocking and starts asking questions, you better be part of the solution rather than part of the problem. Because if they think you're part of the problem, there could be criminal consequence for certain individuals. So if you're aware of widespread malfeasance in the banks with respect to PPP loans, you should really speak with a PPP loan fraud attorney to learn your rights.